Okay, everyone, good afternoon, and thank you for joining me to talk about COVID-19 leave options today. For those of you who don't know me, my name is Jamie Beausois. I'm a shareholder at Kroloff, and my practice here focuses primarily on employment law. So I do all range of things, mostly for employers, ranging from a policy development and review all the way through litigating cases through trial. So what we're going to be focusing on today is COVID-19 leave options with a heavy emphasis on the FFCRA. I have my Q&A and my chat off to the right, so when I keep looking off to the side, that's what I'm doing. Oh, there we go. Okay, so just a disclaimer first. I'm going to give general advice today based on what's currently available from the CDC and other guidelines in the Department of Labor. But this is not legal advice specific to your situation. I do recommend with these issues that you do reach out to your counsel, whoever that might be, to discuss your particular facts, what's going on with your employees, and everything relating to your workplace. It's just not possible to address specifics in a format like this. So we're going to go through today. Here's our outline. The Families First Coronavirus Relief Act. I've got the R and the C switched there, and the exceptions to that for smaller employers. The California Paid Sick Leave Law and how that interacts with the FFCRA. The Family Medical Leave Act and the California Family Rights Act and how those apply to COVID leaves. Disability accommodations under the Fair Employment and Housing Act and the Americans with Disability Act, California School Activity Leave, and some examples that I've put together. And you can feel free to ask questions as we go along using the question and answer box or the chat. And I will make this PowerPoint slides available to all of you after the fact, but I do ask that you just email me and then I will shoot you a copy. It doesn't save and there's no way to share the PowerPoint slides via Zoom. So if you want a copy, just go ahead and shoot me an email and I will get those over to you. So I just wanted to briefly start out with the COVID-19 isolation recommendations. These are important when we're talking about leaves of absence because you may have employees that are asking for a leave of absence due to a recommendation from a healthcare provider or a public health officer that they quarantine or isolate for a period of time. And these recommendations have been changing over the course of the pandemic, and they recently changed again. The recommendation from the CDC was originally 14 days for quarantine. That has been reduced to 10 due to the fact that most people begin exhibiting symptoms within 10 days. So isolation and precautions can generally be discontinued according to the CDC after 10 days of symptom onset and resolution of fever for at least 24 hours without any meds, and with the other symptoms also improving. That can be extended for up to 20 days with those who had severe illness. So employees should be working with their healthcare providers if they're exhibiting symptoms to determine how long that period is. I do know that some of the literature and medical facilities are still recommending the 14 days. I don't know if they'll update that or why that may be, but some of your employees will still be getting 14-day recommendations at this point in time. And those who were exposed but weren't tested and have no symptoms have the 14-day recommendation. And those who had an exposure and recovered from COVID-19 in the last 3 months but don't have symptoms and had another exposure don't need to isolate again. There is an option to discontinue isolation or precautions earlier if the employee tests negative. And again, that should be done in conjunction with the recommendations of a healthcare provider. And at this point, retesting is not recommended for those who were previously diagnosed with COVID and who were symptomatic and who remain symptomatic after recovery. I mean asymptomatic after recovery. Retesting may be warranted for those who develop new symptoms in that 3-month period after they had recovered from a prior COVID-19 symptoms or diagnosis. And for those who never developed symptoms, when you're trying to determine these time periods, the date of the first positive test is what should be used in place of some kind of symptom onset. So when you're working with employees on their return to work and their ability to come back to work, you're going to work with them on what their doctor is recommending, but also you should ask them to take note of when their symptoms first began. Because 10 days later, 14 days later, employees might not recall the day that their sore throat first developed or the day that they first developed a cough. And that's really important to note so that they can be returned back to work. And at this point in time, the CDC is recommending the nasal swab method of testing rather than blood testing for COVID-19 infection. And again, it's important to continually follow up with this information. If you Google isolation and CDC, you can come up with the current recommendations, but they do change from time to time. So then we're going to move on now to the Families First Coronavirus Response Act. This went into effect on April 1st, and it is in effect through December 31st at this point in time. I don't know if it will be extended. I haven't heard anything in that regard. So this applies to all private employers with fewer than 500 employees. So a lot of employers in our community. It is counted, the number of employees are counted at the time that the first leave is to be taken. And how you count the employees matters. If you have right at the threshold of 500, you may want to consult with counsel. You really want to look into how the Department of Labor is currently defining employees. But at this point in time, it does include employees who are on leave or employees who are jointly employed with another employer or those who may have come to you through a temporary agency. Corporations can be considered to be a single employer if their operations are combined. And what we look to when evaluating how to count employees is for multiple entities and deciding whether they should count for one or the other or both is we look at the integrated employer test under the Family and Medical Leave Act. So these are kind of complicated counting metrics. So if you're on the threshold, it would be a good idea to look into those definitions more thoroughly. And it also does apply to most non-federal public employers. And there are exceptions for healthcare providers and emergency responders. So employers may have the option to grant part or not all of this leave. For example, perhaps an employer may want to grant FFCRA leave to first responders who have a health condition themselves, but not to those that may have to care for someone who's having a school shut down. So there's different options available to those of you who are healthcare providers or emergency responders. And it may not apply to your entire workforce, so we'll have to take a look at that. So there are exceptions to this law. Those with less than 50 employees can potentially ask for an exception and deny the right to take leave to an employee because they fall within these exemptions. The first is an exception for financial hardship. So this would mean that providing the leave to the employees would result in the business's expenses and financial obligations exceeding available business revenues and causing the small business to cease operating at a minimum capacity. So this is basically going to put you out of business. If you're going to take advantage of this exception, which does apply to a lot of businesses, you'll want to make sure that you have adequate documentation of both the expense that you would incur in putting that employee on leave, and then also your financial condition and why this would stop you from operating at minimum capacity in case there is some kind of a claim that you didn't provide the leave that was required. There's a second exemption for highly skilled and knowledgeable employees. So if this particular employee who is asking for leave, if they being out would pose a substantial risk to the financial health or the operational capacity of the business, then there's an exception and you can deny that leave. This person has to have specialized skills, knowledge of the business or responsibilities. So this isn't a lower level line employee. This is someone probably in management who's just really critical to the ongoing operation of the business. Basically, you can't run if they're not there to offer their expertise and knowledge. The third is a lack of replacement. So this isn't a particularly skilled or essential worker. Maybe essential is not the right word, but this person doesn't have a very high level of responsibility or operational need. But there isn't enough people who are able, willing, and qualified to perform their job if they were taking leave. So this could be just the inability to find skilled replacements or any replacement at all to fill that position. And that would have a very significant impact on the business in that it wouldn't continue to operate at minimal capacity. So for all three of these are pretty high burdens. So again, this might be an area in which you want to run your particular situation by your counsel to determine whether or not you fall into these categories. But there are exemptions available for employers who really just cannot grant the leave for one of these three reasons. So what does the law provide? It for anyone under 500 employees, it provides, if it doesn't fall within an exception, it provides 2 weeks of emergency paid sick leave. And this is for an employee who is quarantined or who is experiencing COVID-19 symptoms and is seeking a medical diagnosis. And this is paid at the employee's regular rate of pay up to a cap of $511 per day. So that's the first reason that this can be used, this emergency paid sick leave. And so this employee does have to be seeking a COVID diagnosis. So if someone just stays home sick because they have a cough, they think it's a COVID symptom, they think, I think it might be allergies or it's just my asthma acting up. I'm not going to be able to come into work. I'm not going to seek a COVID diagnosis. I'm not going to go to the doctor for this. They would not qualify for this leave. Because they were seeking a symptom, but they weren't seeking a diagnosis. Now, if they have a cough, they're not sure, but they do go and seek treatment, then that person potentially might qualify because they went and saw someone and got a COVID test, for example. Now, if an employee is, the second way to use emergency paid sick leave is if an employee is unable to work due to a need to care for an individual who is subject to quarantine or to care for a child whose school or daycare is closed. We'll talk a little bit more about who they would have to be caring for, but this is paid at 2/3 of the employee's regular rate of pay, up to $200 per day cap. So there are two ways to use this 2 weeks of paid sick leave, and it's up to 80 hours. Now, the next part of this law is the expanded family and medical leave. And this is technically 12 weeks of pay, but 2 of these can be in pay and leave. 2 of them are unpaid unless you overlap it with the sick leave. So if the employee is unable to work because he or she must care for a child whose child care provider is closed, that's the first reason they could use this leave. Or actually, this is the reason they can use this leave. It's paid at 2/3 of the employee's regular rate of pay, and the employee must have worked for 30 days. And that would include if they had been a temp for 2 weeks and then they transitioned to full-time employment. That would include all of the days they had worked for you. The first 2 weeks, like I said, are unpaid. So an employee could use the second reason for emergency paid sick leave to get the first 2 weeks of pay. So it would be possible, hypothetically, for an employee to get up to 14 weeks of leave under this law, only 12 of which would be paid. So if the employee developed or was quarantined, for example, because of their own exposure, and they were staying home for that for 2 weeks, and then a month later, their child care closed due to COVID exposure, and they were caring for their child, then they could have 12 additional weeks, potentially, the first 2 of which would be unpaid. We'll talk about how this overlaps with your paid leave in a moment. I have a question here, 1 second. If an employee seeks a COVID test but doesn't give you proof in a timely manner, are they qualified for FFCRA? What they could give you is they should be giving you documentation relating to the COVID test, not necessarily the result, or they could give you the slip that they had gone to the doctor Most doctors' offices are giving work notes out. The COVID testing sites, I'm not as sure about. So they do have to give you documentation, and we'll talk about what that is, but it's pretty broad. So anything they might give you could potentially qualify. And the question is, if they don't give you that documentation, would you have the documentation you needed to be able to take the tax credit for this? That's what you're really looking for. So under the FFCRA, these are the reasons that an employee qualifies. And this is the list that the Department of Labor is using. So I include this here because this is on their website, and they are the ones enforcing this particular law. And so I include this here so that you can see the way that they describe it. Someone who is subject to a federal, state, or local quarantine or isolation order. Now, that could be a statewide quarantine order if it applies to this particular employee. Early in the pandemic, we weren't sure if that would apply, for example, to California's quarantine order. The Department of Labor has clarified that it does. So if California put in place a strong stay-at-home order again in the fall, for example, this may apply to a lot of employees. Second one is that they were advised by a healthcare provider to self-quarantine related to COVID-19. The third is that they're experiencing symptoms and seeking a medical diagnosis. The fourth is that they are caring for an individual subject to 1 or 2. The fifth is that they're caring for someone whose place of care is closed due to reasons related to COVID-19. And then number 6 is a placeholder for any other similar condition that the Secretary of Health and Human Services may define. And they have not defined any, so 6 doesn't apply right now. And just for noting, a healthcare provider under this law is a licensed physician, nurse practitioner, or other healthcare provider who would be permitted to issue a certification for purposes of the FMLA, the Family Medical Leave Act. So this piggybacks on the regulations that were issued for the Family Medical Leave Act. And you can look to those regulations or publications that were put out on the FMLA to evaluate whether or not the person issuing the note to your employee qualifies. So when an employee is caring for someone else, the question often arises, what types of individuals can they care for? Is it their neighbor down the street, or is it obviously their own child? But we've got some clarity from the Department of Labor. And this must be an individual who genuinely needs the employee's care due to a quarantine or isolation order. So someone who does not need care, who can just go about their daily life on their own in quarantine, perhaps a spouse, is not going to require care. Now, a child would require the employee's care because you can't just leave your 6-year-old at home alone at the quarantine, and they can't go to daycare because they're in quarantine. Caring for this person must prevent the employee from working and teleworking. And this is an important note that I should make, which is that if an employee has the ability to telework, to telecommute, they do not qualify for leave. So this is for leave that people cannot come into the office, or if telework is available for that person in that position, can't telework either. Now, having a 2-year-old at home may prevent them from teleworking effectively, or for at least part of the day. Or someone who's ill would also prevent someone from teleworking if they're requiring a lot of care. The individual must be an immediate family member or someone who regularly resides in the employee's home. So this isn't going to care for a niece or a cousin or someone who you don't normally have responsibility for caring for. And it has to arise, it could also arise from a relationship that creates an expectation that you would care for that person in a quarantine or self-quarantine situation. So for example, if you had someone who's disabled that you regularly care for that doesn't live in your home and they were in quarantine, that may apply. Also, a child over 18 who has a disability who can't care for him or herself would qualify. And you should be, we'll go through the documentation about who should be asking or what kind of information they have to give you about who it is that they are caring for. I have another question, 1 second. So this question is about returning to work after quarantine. Is there any documentation needed or retesting needed for an employee returning from a positive COVID-19 after self-quarantine in order for them to return to work? So there are self-certification forms that you could potentially use to document that the employee's last symptom ended on a particular day. So I've made these available to some of my clients, and some of the human resources organizations are putting out these type of self-certification forms. And so you can use that where the employee certifies that they became ill on X day and now it's been 10 days since their last symptom or since their positive test and they haven't developed any symptoms, they haven't had a fever for 24 hours, etc. And a lot of employers are just relying on medical notes. They would prefer to have a doctor release that person to come back to work after they tested positive or after they developed COVID symptoms. So that is up to you. The option does exist for self-certification, but I know a lot of employers are just more comfortable with medical notes releasing employees to return back to work after they've had COVID. So there were initial questions about whether this leave can be taken intermittently. And the Department of Labor has released some guidance on this, and also there was a district court case on the East Coast, I can't remember which district, about, I think it's on my next slide, about whether this can be taken intermittently. So the outcome of this at this point in time is that employees do have a right to take intermittent leave in situations where health and safety is not at risk. For example, a childcare closure could be due to an exposure in another classroom where your child wasn't actually exposed, but the school has closed for cleaning or something like this. So that could be one. Another one that the Department of Labor says is allowed right now is distance learning. So if an employee is having to take time out of their day to help their child with distance learning, that could potentially qualify. And they could take it in any increment that the employer and the employee agree on. So if your kindergartner needs 4 hours of distance learning a day, that potentially could qualify for 4 hours a day used intermittently. Now, sick leave would have to be for the employee's health condition, would have to be used in full day increments and continue until the individual was no longer sick, didn't have the qualifying reason. This is because we don't want sick people coming back to the workplace for 4 hours a day. There's a risk of exposure. And it's not permitted for the following reasons which have a higher risk of viral transmission. The employee is sick or quarantining, or a healthcare provider has advised them to quarantine. This person was experiencing symptoms and taking leave to obtain a medical diagnosis, even if they don't yet have a positive test result, or if they're taking care of someone who is subject to a quarantine or isolation order related to COVID, or that person has been advised to self-quarantine for concerns related to COVID. So if it's a pure child care issue, then that is something that can be taken intermittently on the agreement of the employer and the employee. If it is not, then that person should be taking that leave in a chunk until the illness or the quarantine is over. Okay. So when someone comes to you and you learn that they have a qualifying reason to take this leave under the FFCRA, the first thing you need to do is determine how many hours they have been working. So how many would they be eligible for? And we have some guidance now from the Department of Labor on how to count. So you count the hours of leave that they are entitled to based on the hours that they are normally scheduled to work. If their schedule varies, you use a 6-month average to calculate the daily average. If the employee hasn't worked for you for 6 months, and they're, for example, they've been working for you for only 1 month, what you use is the agreed upon hours at the time of hire. So even if they hadn't been working full time, but your offer letter said you're going to be a 40-hour-a-week employee, you would use the 40 hours a week. Because there's a lot of circumstances right now reducing hours lower than what had originally been agreed upon. But if this person came to you and you said, we're going to see how it goes, we'll give you work as it comes, there's no fixed number of hours, they've worked for you for 2 months, then you're going to average the hours over the 2 months. And it's important to note that the calculation does include overtime hours, but that doesn't mean the employee gets to take extra leave. So the question, I just got another question about positive test results. We're talking a lot about positive test results, but what if someone was exposed and their test came back negative? Can they start back to work? And the answer depends on whether they were exhibiting symptoms and what symptoms they were exhibiting. But if they were asymptomatic, if they were just exposed to COVID and took a test for that reason, and their test came back negative, typically I do think that the CDC, without any symptoms, does allow that person to come back to work at that point in time. If they were exhibiting symptoms, if we go back to that first slide I had, they have to have been fever-free for 24 hours. Their other symptoms have to be declining, and the negative test could allow them if they had those other factors present also. And this is one of the reasons that a lot of employers do want a medical note to release someone back to work if they've been symptomatic. Now, if they come back with a negative test, then I think the common practice is, and the CDC recommendation does allow them to come back to work. Okay. And then even if this employee, so for example, if an employee, jumping back into this slide, if an employee normally works 50 hours a week and they take 1 week of sick leave expansion leave under the FFCRA, they could take 50 hours that first week, but we still have the 80-hour cap, which would mean that they would only be eligible for up to 30 hours the next week. And you do not have to pay at an overtime rate for this leave. Hopefully that makes sense. The question is, I have 27 employees, do I need to apply for a waiver? There is no waiver process. You just need to make sure that you have the documentation in place should there be a claim or another issue arise, or the Department of Labor is, I understand, beginning to enforce the law. So you just want to have the documentation in place that you fit one of those 3 exceptions. There's no way to get a waiver. You would just deny the leave and then make sure you have your documentation in place. So then we've decided how many hours this person's entitled to. Now we're going to see what rate at which do we pay, can't speak suddenly, at what rate do we pay them? So the Emergency Paid Sick Leave Act offers a different rate of pay than the Expanded Family and Medical Leave Act. The Emergency Paid Sick Leave Act, for those 2 qualifying reasons, provides for the employee's own health condition 100% of their regular rate of pay up to $511 per day for a total cap of $5,110. Expanded Family and Medical Leave provides 12 weeks of leave, the first 2 of which are technically unpaid, and the employee can use Emergency Paid Sick Leave Act pay if it's available, or any other employer-provided leave for the first 2 weeks. And that rate would be slightly different. It would be 2/3 of the regular rate of pay up to $200 per day, or $2,000 total. So you don't get the $511 rate of pay for cap for caring for someone else. That's for an employee's own health condition under that first bullet that we had under the sick leave law. So the last 10 weeks potentially of the Expanded Family and Medical Leave is paid at 2/3 of the employee's regular rate of pay, up to $200 per day, or $10,000. I just got a question about how it interacts with FMLA, and it is not in addition to, it works in conjunction with, and we're going to go over that next. So calculating the amount of pay. So Once you've decided what the cap is for the type of leave that employee is taking, then you decide what their rate of pay is multiplied by the number of hours up to the cap. So the employee's regular rate of pay includes things like overtime pay, bonuses, or non-discretionary bonuses, I should say, and other types of pay that you would normally calculate into an overtime rate. And that it has to be the greater of these three things, the state or local minimum wage, the federal minimum wage, or the employee's regular rate of pay. In California, we're going to be above, so it's going to be number one. The regular rate of pay is averaged over a period of 6 months prior to the first date the leave is taken. So you don't have to keep updating this each week an employee uses some leave. You can use the same number for the full amount of time they're using the leave, but you're going to take an average. So if they received a pay raise in March, that's going to increase slightly their regular rate of pay for the purposes of this leave. Or actually, it would decrease it because the rate is slightly lower. But you want to make sure that you're calculating this correctly and that you are checking in with your payroll company on what rate is being applied if your employee is sometimes working overtime or sometimes receiving bonuses or some kind of hazard pay. Something like that is going to increase their rate of pay. So the calculation is down here on this bottom bullet. Divide the total pay for employment, except for any statutory exclusions, which would be healthcare premiums, amounts that are, this would go with the regs for the Fair Labor Standards Act. That's what would apply. And discretionary bonuses would be excluded. And you divide that by total hours actually worked to determine the hourly rate. So basically it's total pay divided by hours actually worked to come up with the average for 6 months. So this slide here and what we're going to talk about next is how this interacts with your existing paid leave benefits. So under the Emergency Paid Sick Leave Act, this is in addition to employers' leave entitlements. So if you also offer sick leave, which everyone in California does, this is allowed to be taken first. However, the employer and the employee can agree to supplement. So if your employee earns more than that cap each day, or if they earn more than that cap each day and they want to supplement to get up to 100% pay by using some of the accrued sick leave they have under your company policy, then that's allowed. For Expanded Family Medical Leave Act, for the first 2 weeks, the employee can choose, but can't be required, to take the 2 weeks of paid sick leave under the EPSLA to get their $511 a day. Or they can choose to take leave during those 2 unpaid weeks from any accrued leave they have under your company policy, but they can't use both. But again, they can supplement if they choose to. If they have used up all of their EPSLA, emergency paid sick leave under the FFCRA, then they can choose, but they can't be required to draw down the employer paid leave. So for the last 10 weeks of this, basically child care leave or other care leave, care for others, the employee can elect or be required to take this concurrently with any employer provided leave. The employer must, if you're going to require that, you have to pay full pay during the leave until your leave under your company policy is exhausted. And then you pay the 2/3 that was required under the law and provided for under the law. And you can, again, under this agreement for the last 10 weeks, supplement up to the employee's normal compensation. And I don't know if I have a slide on this, but how this works is that you can then deduct this from your payroll taxes that you're obligated to pay quarterly to the federal government. So if you're using any of the large payroll providers, probably most of the small ones by this point in time, they have categories for emergency paid sick leave and expanded family medical leave. I think they have 4 categories for the 4 different ways you can use it. they automatically track that and then reimburse you or don't charge you for the amount of tax that would be owed for those wages. And I understand that it's pretty simple to use. So do go ahead and work with your payroll company to figure out how that works. But that means that you're going to get a one-for-one reimbursement from whatever payroll tax would be owed. So the federal government is essentially paying for this leave, not any employer supplement. So it would be only the FFCRA portion, the 2/3 of pay up to the 200 or the full pay up to 511. Anything you pay on top of that is on you and can't be deducted from payroll tax liability. And then I haven't had anyone actually do this, but I understand that if you end up paying out more than the payroll tax liability, that you get a refund check. I'm not sure how fast that is or how that's working, but technically you should be entitled to a refund for the wages you paid under this leave law. So there has been a lot of confusion on furloughs. Initially, the position of the Department of Labor has been that an employee who was placed on a furlough before this law went into effect, or even during this law, is not eligible for FFCRA leave, because the reason that they're taking the leave is because there was a reduction in available work, not because of one of the qualifying reasons, illness, healthcare, quarantine. And this was challenged by the state of New York recently, and the court struck down the rule and threw into question this rule of whether FFCRA leave benefits can be available during a furlough. The court found that the FMLA regulations, the court found that the law did not specifically allow an exemption for furlough. So if an employee was on a furlough and had a return date, that they could apply for this leave if they met one of the qualifying conditions. So this is kind of up in the air now. I checked this last week. I haven't checked it since then. What we'll have to wait and see is whether the federal government appeals this decision or whether they revise their final rule that was struck down. So we're watching that. This is contrary, for those of you who have 50 or more employees, to the FMLA, which does not require employees to pay during periods where there isn't work for the employee. For example, if you're always shut down for 2 weeks in December, that doesn't count against an employee's FMLA leave. So this is a bit confusing and could potentially throw into question a lot of employers who are suffering slowdowns. So we're going to have to keep following this and see what happens. The FMLA and the California Family Rights Act both apply to employers with 50 or more employees. And there are some other requirements in terms of how many hours the employee has to have worked, usually a year, 1,250 hours, and they have to be working within a radius of 75 other employees. So the question here is whether it's in addition to FMLA leave. And the answer is yes. So under the paid sick leave, I just was very confusing. The Paid Sick Leave Act is in addition. The Expanded Family Medical Leave is not. So if an employee elects to apply their emergency paid sick leave to the first 2 weeks of EFMLA, then those 2 weeks are still counted as EFMLA. They don't get to double dip. But EFMLA, the Expanded Family Medical Leave portion of this law, is part of the typical FMLA entitlement. So you can deduct time from for standard FMLA purposes. If someone goes out for hip surgery, that reduces the amount of time they can take off for the Expanded Family Medical Leave Act for a COVID-related reason. And it can count against their entitlement for future FMLA leave. So if you have 50 or more employees, it is very important that you count and run these simultaneously so that you know which ones they are running down at any given time. So for example, an employee who took 2 weeks for surgery in January of this year still has 10 weeks available under the EFMLA if they were covered at that time. And so they could use the 10, but not the 12, for example. So how much notice is required from the employees? This was also at issue in that New York case, and the court struck down part of this as well. The Emergency Paid Sick Leave and the Emergency Family Medical Leave Acts provide guidance and requirements for how much notice is required. So I just have them copied and pasted here from the law. After the first workday or portion thereof, an employee receives paid sick leave under this act. The employer may require the employee to follow reasonable notice procedures in order to continue receiving such paid sick time. So this is reasonable notice. So once they go out sick, they have to keep you reasonably apprised of their status to continue receiving paid sick leave. They can't bring in a doctor note that says I can come back in 2 days, which I wouldn't think they would in a COVID-related situation, and then not update you after that and continue receiving leave. And the FMLA, the employee must provide notice in any case where the necessity for leave is foreseeable as soon as practicable, basically. So this is, again, a reasonableness standard. So if school closes today, they don't have to tell you yesterday, but they need to tell you basically as soon as they know and are able to that they're going to be out for a certain period of time, and they have to tell you how long that might be if they know. And then here's our documentation slide in terms of what documentation you should keep on these leaves. So first, the employee's name, that one's pretty straightforward. The dates that they request the leave for, and the dates that you provided it for, which could be different as things evolve. Sometimes we forget to update those dates in the file. A statement from the employee about the reason that they're taking the leave. So this is due to a quarantine order. They have to tell you the name of the governmental entity that issued the order. For example, if it's the San Joaquin County Health Department, then that would be what they would tell you. If it's from another county, you get to know that. If they were advised to self-quarantine, they need to provide you with the name of the healthcare provider who advised them to self-quarantine. If they're experiencing symptoms and seeking a diagnosis, that statement is sufficient. So I would ask, this is very broad and it relies a lot on the honor system. So the employee gets to just tell you what they're doing. And that's because across the country, there has been a large problem with getting documentation. Testing sites aren't giving it, doctors' offices are backed up, and or if someone can't even get in to see a doctor for days, or to get a test for days. And so we don't want those people in the workplace potentially contaminating everyone else just because they can't get a note from Kaiser. And so this is the initial requirement, is that they just tell you that that's what they're doing, and that would qualify them for this paid leave initially. Now, coming back to work, you could ask for a doctor's note. That is still allowed, and you don't have to allow them back until they have it. But this is the documentation that you need to qualify for that tax offset. So caring for an individual in quarantine, it would be the name of the individual, their relationship to your employee, and the government entity or healthcare provider involved in that quarantine or health condition. And then the school child care closure, the name and ages of the children, the name of the school, the name or childcare provider. If it's grandma and grandma comes down with COVID and is no longer providing childcare, then it's grandma's name. And the reason that provider is unavailable due to COVID-19. So if grandma is sick, that's the answer. If the school had an exposure and shut down for cleaning, that's the answer. Or if this could even be that the camp didn't open this year because it wasn't allowed to due to government restrictions due to COVID. So they have to provide you that reason. And they have to tell you that there's no one else available. And this could change over time, because sometimes a husband is on a furlough, he's able to watch the child, and then he returns to work, and this employee might be taking leave. So this can change. And you just want to keep updated with the employee on this. And if the child is over 14, the employee should state the special circumstances that exist requiring the child care. So this could be for distance learning, for example, because a 14-year-old may not be willing to sit at their computer and do distance learning alone. They may need more supervision. They may have some type of disability or learning issue that requires more assistance, or they might just be failing at distance learning and the employee decides that they need to be home more in order to supervise that. And then it's also recommended that you maintain documents that you use to calculate their leave eligibility, the number of hours, and the rate of pay, so that you can prove that you did that correctly. Okay, there's more questions. 1 second. Okay, we have an employee that has provided a doctor's note that has put them on leave until we are in phase 2 of the state's reopening. Is this okay? Yeah, if that's a medical note, then that is okay. We're going to talk about Fair Employment and Housing Act and Americans with Disabilities Act accommodations in a moment, which cover some of this. But that employee probably has a health condition or something else going on that is causing them to be more vulnerable. So I would make sure I understood what that actually means. What's phase 2 to that particular doctor or employee? So you might want to do some follow-up there and get more clarity. But yeah, I think a doctor's note taking them out is probably going to be something. If you want to deny the leave, I think you should definitely consult with your counsel because that's probably a complicated one. But potentially, yes, there are employees that are being placed out on leave for longer periods of time because they have an underlying condition that does put them very at risk. Would we need to provide a hard copy for employees to sign off on after they come back to work? Oh, I'm not sure a hard copy of what. Employers are doing return to work certifications from the employee, but I'm not sure what else they would be signing off on to come back to work. Okay, this law comes with retaliation protections. So you can't retaliate against an employee for asking about the leave, for using the leave, for taking the leave. You can't require an employee to find a replacement to cover their shift. You can't require an employee to use other paid leave first. We went through how it interacts with other leave. Here's the reimbursement slide. I knew I had it in here somewhere. So you can get a dollar for dollar offset against payroll taxes. So California paid sick leave. The Department of Industrial Relations, the Labor Commissioner, have issued some guidance on this in an FAQ. They have determined that California's paid sick leave can be used for COVID-19 exposure or self-quarantine because that falls within the preventative care aspects of California's sick leave law. They have also said that an employee who is quarantined cannot be required to use their paid sick leave. They can take unpaid leave for that if they want, or some other type of leave, which we'll go through here briefly at the end, like unemployment, but you can't necessarily require them to use paid sick leave. It depends on the type of quarantine actually, but if it's like a statewide stay-at-home order, that's different than the employee being advised to quarantine. For their own health condition, they might not be eligible for unemployment for that, perhaps disability, but you can't require them to use their accrued paid sick leave. If they do decide to use their paid sick leave, you can only require them to take it in a minimum of 2-hour increments. You can't require them to take the whole day. And how much paid sick leave they use is up to the employee. And sick leave can also be used for a school closure or child care closure at the employee's discretion under the preventative care provisions as well. We talked about FMLA and how those overlap. Those are both federal laws and they were designed to work together. The California Family Rights Act, however, does not always run concurrently with the Family Medical Leave Act. So it's important to track these two separately, maybe more similarly like we do for pregnancy because they don't run concurrently. So FFCRA leave for family care may not run concurrently with FFCRA leave, with CFRA leave. if the reasons for the leave are not included in the CFRA. That's what that's supposed to say. For example, if you're caring for a child due to a school closure, there's nothing in the CFRA that covers that. So that would not be running concurrently. And also the FFCRA may not run concurrently with CFRA due to a COVID-19 illness. It has to rise to the level set forth in the CFRA, which would be a serious health condition. And COVID-19 may not be a serious health condition for every employee, especially if they're asymptomatic and had a COVID positive test. So that is something that is evolving in the law, and we aren't 100% sure about now, but it is something to be aware of and to consult your counsel with if you're dealing with a particular situation and how you should run CFRA leave consecutively with this FFCRA leave. So when we're talking about employees with disabilities, that can be a chronic health condition that's normally hidden from you. This could be diabetes, this could be asthma, this could be chronic fatigue syndrome, this could be a lot of different disabilities, it could be lupus, it could be anything that impacts a major life activity. And so when someone comes to you and says, I can't come back to work because of my disability, because I have this underlying health condition, that's something to take seriously and to look at in terms of whether you need to accommodate that person's disability under the ADA or the Fair Employment Housing Act, the FEHA. And so your obligation as an employer who becomes aware that someone is disabled and has requested an accommodation is to engage in the interactive process with them to determine whether the employee is able to perform an essential job function with or without an accommodation. And the Fair Employment and Housing Act does apply in California to employers with 5 or more. So this is an obligation that, that applies to most employers. And it should also, when you're evaluating whether or not you can grant this leave, for example, this person may ask for telecommuting because they don't want to be exposed to COVID-19 in the workplace. Other accommodations may be available that you want to look at, or maybe you can grant the right to telecommute. But do be aware that when you're granting a right to telecommute now or any other accommodation, this could potentially set a precedent for future requests. So once the pandemic is over, if someone with a disability asks to telecommute, you're going to have to explain why that's no longer something that's available in your workplace, why it now causes an undue hardship when it didn't during COVID. So that's just something to be aware of. And this is just a note, most employers, I don't think, want to exclude employees from the workplace, but if you're concerned that you don't want someone coming back because they are at higher risk, that is a very, very high standard to meet in order to not have discriminated against that employee. The standard is that the disability must pose a direct threat to the employee's health that can't be eliminated or reduced by a reasonable accommodation. It's a very high standard. It has to be based on criteria specific to that person, including your workplace, their workplace, the recommendations of physicians, etc. So this is one I also recommend before you exclude someone from the workplace because of a disability, because you think they might be in danger. That's another one where you really want to talk with counsel. So I did a little bit of searching on various websites, disability access websites and some others. And these are some possible accommodations that I saw recommended. They might not work for your workplace. They may create an undue burden for you. You have to do a case-by-case analysis, but some of these are possible. Telework, modified work schedule, maybe when they are in the office when less people are, for example. Restructuring to reduce exposure to clients, customers, and coworkers. For example, if they had a tangential task they did, like answering the door, maybe that someone else could do that task. Elimination of other marginal functions, provision of protective equipment like masks or gloves, modifying the workplace by putting up plastic barriers, moving that person to a less populated work area. Maybe they don't need to work in the main area. They could be off somewhere where there's less exposure and they could come in a side door or something like that. And then also providing an extended leave of absence, which would be potentially unpaid or paid by some kind of a leave program, maybe like a disability leave, but that should also be considered. I just want to note briefly that the California School and Childcare Leave includes employers with 25 or more employees and gives up to 40 hours of leave to care for school-related emergencies. And employees can be required to use vacation and PTO, but not sick leave. So if this applies to you, then it's something to track alongside the FFCRA. Now, you can't require the use of vacation and PTO for FFCRA leave, but if this person had exhausted all of their FFCRA leave, they may then be entitled to school and child care leave, or they could be running concurrently and they could have used up both. But it's just important to be aware of this. Okay. I just have a couple more minutes, and this is my last substantive slide, which is what wage replacement is available for your employees that are on leave other than the FFCRA pay, which is actually, I have included here too. So first, we have disability insurance, which is available to employees who are not able to work because of a medical quarantine or illness related to COVID-19. That's their own illness. We have paid family leave, which provides pay for those caring for ill or quarantined family members. It's implemented through EDD also. We have unemployment insurance for lost job or lost job hours. So if the hours are reduced for the employee, they can get a partial unemployment benefit. We have pandemic unemployment assistance, which provides unemployment type benefits to those who are running their own business or are working as an independent contractor. We have California paid sick leave, which we've talked about a lot today for the employee's own illness or caring for a family member for preventative care. We have supplemental paid sick leave for food service workers. So this is a California specific law applying to food service workers where the employer has 500 or more employees across the US. We have FFCRA, emergency paid sick leave, which is the qualifying reasons we went through. We have the emergency paid family leave, which of course is the focus of this presentation. There are also some local government paid sick leave programs. So Los Angeles, San Francisco, and San Jose are the ones I am aware of right now that require additional paid sick leave due to COVID. So if you have employees working in those cities, that is definitely something you want to look into and make sure to comply with. And then we have workers' compensation. Employees who reported to work between March 19th and July 5th and tested positive, there was a presumption in place due to an executive order that those employees contracted the disease at the workplace. And so they may be eligible for workers' compensation benefits for that reason. Or they could be eligible for workers' compensation benefits going forward if they were exposed to and contracted the disease at work. That's a different presentation, but be aware that does cover some of this leave also if the employee if you have an outbreak in your workplace and they caught it at work. And then I had some examples, but I've run out of time, so I'm just going to jump to the end. So if anyone has any more questions, I will stay here and answer them. I know it was a lot of information and it was very detailed, but hopefully it at least allows you to spot issues that you're going to experience while you try and apply these leaves, especially the FFCRA, which applies to now so many employers because it's that 500 and under figure. So feel free to put questions in the chat or in the Q&A box. And if you would like a copy of the slides from the presentation, please do email me and I will make sure to get a copy of those to you. So thank you so much for joining me and good luck as you continue to navigate this ongoing situation with your employees.